It's Entertainment Law Update, episode 184 for September 2025. Hello, everybody, and welcome back to another episode of Entertainment Law Update from Los Angeles, California. I'm Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamara Bennett.
And we are grateful to you for joining us for this episode of Entertainment Law Update, our podcast by entertainment lawyers for lawyers and law students about entertainment law, where each month we round up notable cases and news and information and keep you informed and hopefully a little bit entertained. And we do want to say we welcome your feedback. So if you've got something to share with us, please do send it over. Suggestions, any kind of input at all. Visit entertainmentlawupdate.com and use the little voice widget there on the side of the screen. Or you can just email us, entertainmentlawupdate@gmail.com. Tamara, what's new in your neck of the woods?
Oh, not too much. Ready for fall to get here. Happy college football is here. Had a great trip to Austin for the Entertainment Law Institute CLE. Want to say a big thank you and shout out to the folks who listened to our podcast, who came up and spoke to me. So thank you so much, Edith, Tom, Joe, and I've got one more who's escaping me. I'm sorry. I meant to make a mental note and then didn't write it down. So forgive me. I'll have it by the end of the show to give everybody a good shout out.
Well, that was a little earlier in the year than it's been in the past few years.
It is, I think, kind of switching it up. So I moved it to mid-September, early September versus late October, November.
Oh, that's great. That's great. Well, since you and I last spoke, I have been running around the country like a madman and finally back at the desk and in the house and able to do my work and stay focused a little bit better. But had a great time speaking at Podcast Movement when we saw each other last. And then I went on to VidFest and then an authorship conference and then FinCon up in Portland, Oregon. So, Dallas, Atlanta, and Oregon, and now back to LA. So
wow.
I'm glad to just be able to sleep in my own bed.
Yeah, be home. What is FinCon?
It's a financial influencers conference. So a lot of bloggers and podcasters in the financial services, financial advice space. And it was in a town that I love where my sister lives. So I took the opportunity to go and visit. And I wasn't on a stage for that one, but
was it in Bend?
No, it was in Portland.
Oh, Portland.
So,
okay.
Yeah. Nice town, nice weather that week.
Yeah.
And can't complain about a thing. So anyway.
That sounds super fun.
Yeah, well, enough chit chat. It's one of the things we talk about the podcasting conferences is people hate the shows where there's lots of chit chat up front. So
yes, let's proceed because I've seen feedback on other podcasts where it says, "Can you timestamp this for when you stop talking to each other?"
Right. Well, we'll jump right into our AI area in the news. Big settlement proposed in the Anthropic lawsuit, although not nearly as big as a potential judgment could have been. Largest copyright settlement ever involving generative AI. Anthropic, the leading company in that space, has agreed to pay $1.5 billion to settle that infringement suit brought by a group of authors. What that means is about $3,000 for each of the estimated 500,000 books covered in the settlement. So, back in June, the district court had ruled that Anthropic's use of books by the plaintiffs to train their AI model was fair use in that it was exceedingly transformative and that authors don't have a right to exclude the company from using their works to train the technology as long as Anthropic had purchased the books. And the ruling also stated that digitizing the books that were purchased in print form was considered fair use. But with respect to the pirated material, which was this, the number started out around 7 million different titles that were pirated copies that were to be treated as training copies. They're building a library of this training material. And that big scale illegal downloading was not okay and probably not fair use. So the judge had set a trial to start in early December for the piracy and damages both actual and statutory damages involved in that. And now we may never see the day for that trial to actually happen, nor any appeals that might help us better define and re-articulate what is the fair use, what are the boundaries in these kinds of cases. But the settlement is anything but finalized because the judge has said that he's disappointed with it. He says it leaves many issues unresolved. He says counsel has left important questions to be answered in the future, including respecting the works list, the class list, the claim form, and particularly for works with multiple claimants, the process for notifying and opt-out and re-inclusion and all those things that you have to deal with in class action cases. So the judge wrote, all of these points must be proposed and approved by the court before October 10th. So that's about 2 weeks from today, I think. 2 weeks today? Maybe a little longer. Anyway.
Yes, and they're having a hearing tomorrow, if our date's still correct. Today's September 24th.
Yeah.
Yeah, and it's supposed to be a hearing on September 25th with the judge.
Yeah, to discuss the settlement and deadlines for those additional details. And the judge said, and this is, we don't hear judges talk this way very often, but he said, well, we'll see if I can hold my nose and approve the settlement. So
I think he means it stinks. Is that what he's getting after there? And you know what's kind of mind-blowing to me, of the 7 million books downloaded, only 500,000 will probably meet the requirements to benefit from the settlement. And that was, they have to have an ISBN or ASIN number. They have to have had a copyright registration within 3 months of publication or before the download occurred. So that's to qualify under the statutory regime for attorney's fees and statutory damages. And then they also required that the copyright be registered within 5 years of publication. And that goes to the validity of what's in that registration. But I don't think that requirement is a standard requirement for statutory damages and attorney's fees. It can't be.
No.
But it just goes to the presumption that what's in the registration is valid. So, so I thought that was interesting.
So of the 7 million books that were apparently illegally copied, only 1 in 6. Is that what it is? No.
Yeah, only half of a million. Yeah.
Yeah. I mean, were actually seem to be eligible in that settlement thing. So, yeah, I mean, it makes you wonder if there are a lot of authors that are just going to be left out in the cold here, or how much of that is public domain work, and those kinds of things.
That's probably. I mean, and you'd think there'd be enough in the public domain, but I guess not.
Yeah.
To train on.
So,
don't we have a lot of great classics that are public domain that you could train on?
You would think so, but
you would think.
But the other thing is these language models do have to be sort of modern in their language. So anything more than about 100 years old is going to have sort of archaic constructions of sentences and things like that might be not ideal to train AI with.
Yes, I'll give that point to the tech companies.
But even so, they probably have.
There's still plenty,
material, right? And an AI wouldn't be very good if it hadn't been trained on Shakespeare and Joyce and some of the older material that really kind of sets the tone for the way we operate these days. So
right, okay, Winnie the Pooh, Sherlock Holmes,
exactly, and that's fairly recent public domain.
That's right, recent public domain. So
yeah, it's interesting. So. The issue of fair use at least seems to be resolved. Well, there are some boundaries that have been set up, so the settlement's not going to address all these other big issues. And the judge now seems to be focused on sort of details about what books are eligible and which authors and how they're going to be paid and those kind of things. That's what you do in a class action, I guess. So it's interesting. We're going to be watching. There's lots more AI law to come. This is
oh my gosh. This is merely the
maybe we
tip.
Could change the title of the show to AI Law Update, but
ooh,
or somebody else can do that show as
entertainment. And there's probably plenty of those happening.
You're right. Yeah. But on the flip side of AI is this, as useful a tool as these AIs can be, and some of them are very, specifically aimed at lawyers and have some guardrails set up, I think, for the use by lawyers. But the Texas Bar has published a toolkit
Yeah,
to give guidance.
they have, and we've put a link in there. I think it would be beneficial no matter what state bar you're in to take a look because it also references the ABA. Clearly, you need to be checking with the state bar for the states in
Yeah.
which you're licensed to see what their guidance is. I am sure the toolkit references the most recent ethics opinion related to AI. I don't have that number on there. Uh, a couple of points that just kind of make sense is we have a duty to understand technology, and this is a new technology. So we need to understand that before we stop implementing it. As you and I have discussed many
Yeah.
cases, it's always the horror story of where the information wasn't verified. We have a
Mm.
duty to verify, vet AI tools.
Yeah.
Not all of them are created equal, as well as, part of that is reading their privacy policies, their confidentiality policies. In Texas, we have I don't know if this is unique to Texas or not, but it's something I think is really important if you're licensed in Texas. We need to obtain written consent from our clients for using AI tools.
Oh, interesting.
And the question that raises for me, do we not already use AI tools all the time that are not generative large language model AI
Yeah.
tools? I mean, what really is that definition of artificial intelligence? And I'm not sure if that's defined in the toolkit,
Hmm.
um, because there are many things we use that help generate I mean, there's
Hmm.
ways within just good old fashioned Microsoft Word without Copilot to generate documents that are automated. So I don't know how broad that is. Clearly, it's going to cover if you're using like Westlaw Co-Counsel, which is their AI product,
Sure.
ChatGPT,
Mhm.
Claude, Anthropic. The other thing about the Texas,
Well, before we move on
uh,
from that, so I guess the caveat is our engagement letters, our fee agreements really need to include a
they
disclosure,
do.
or say, hey, in order to streamline our processes and keep costs down, we're going to we're going to use whatever tools, including AI, that will enhance our ability to do our job efficiently.
Yeah. And so you hit on this point number 2, keep the costs down. So you have to have fair and ethical billing practices related to the use of AI and only bill clients for time worked. So if AI makes it faster, now at this point, AI is making it slower.
Sometimes,
So
yeah.
can I bill for my learning curve? I don't think so. And you need to clearly communicate and agree on the generative AI and your fee structure. I I don't think this usurps the ability to flat fee matters if
Right.
you offer a flat fee. Um,
No, I
but
mean, well,
you
again,
do if you're billing hourly and it cuts your time to write a cease
yeah.
and desist letter from 2 hours to 1 hour
Mhm.
or 2 hours to 10 minutes,
Yeah, I mean, well,
yeah.
and even if you were flat feeing, or if you did the allocated a certain amount of time for each task, rather than task-based billing rather than hourly billing. If
Oh,
the
okay.
tasks are taking you less time than they used to, maybe you got to look at your pricing on those tasks. And
Right, and, I've had some interesting conversations with professionals in the legal services
Mhm,
industry,
mhm.
not just attorneys, and so I'm just gonna ask you this question, do you think AI is gonna take the job of the legal assistant, the paralegal, the staff person who supports us as attorneys?
I think that job is going to be replaced by an AI technician who can do the same, can get the same outputs out of the machines, but do it faster and more efficiently. I think that,
Okay.
yeah. I think we'll see. I think it's a skill that legal assistants need to develop if they're going to keep their jobs.
That's right, and that's kinda my thought process on that is it's not gonna take away somebody's job, but if you're gonna be in the workforce for the next 5, 10, 15, 20
Yeah.
years, and as attorneys too,
Yeah.
I think we do have to learn it because
Yeah.
that is just it's like going from the typewriter and carbon paper to the word processor.
Fax machine to email.
Yes.
Uh,
Oh my gosh, yes. I don't know, the fax machine I'm sorry, folks, you can fast forward. I'm gonna tell a quick little story about the fax machine. So this was in Nashville when I worked in the music business. Before I was an attorney, I worked with songwriters, very sensitive people, do not want to let folks see their lyrics until they're really ready.
mhm,
Get it. It's their creative work. We had just got a fax machine that I went and bought for the office.
mm,
Had to go, like, to the actual printer store to get it. Anyway, one of the songwriters was going to fax her draft lyrics over to the co-writer,
hmm.
and she said, "Well, Tamara, can we put it in the envelope before we put it in the machine?" I'm sorry. I thought that was worth the break.
Yeah, no, that's great. That's a terrific story.
Anyway, we're not gonna be able to stuff the AI back in the envelope, folks.
No.
That's all I got on AI. Moving along.
Well, just back to on the billing subject, the other thing I'll say is that even though the initial briefing or writing of a draft or a brief or something, it may be very quick using AI tools, this double checking and verifying and they still call it shepherdizing the cases and making sure they're still relevant and real and the
Oh,
citations
yeah,
are
I guess that's still the word used.
yeah.
But, yeah, you gotta check site check.
Yeah, and I think that all of that is going to take I think that's where a lot of the time went anyway in a lot of, litigation posture kinds of cases anyway. The motion might be the same from case to case, from, year to year, but as cases update and things, you would have to update and you're working from templates and a lot of these things anyway.
Right.
So the customization and the tailoring. And the other thing that I think AI will never replace is intuition and judgment and just the voice of experience, the wisdom. The AI may be very smart, but it's not very wise.
Mm.
So
Oh, that's a great very smart, but not very wise. And I think so, even though you can say, "Well, write it with an upbeat tone, write it with a trustworthy tone,
yeah,
write it aggressively," right? I'm still like,
yeah, but the intuition of just knowing, oh, that sentence is going to trigger my client, or those kinds of things. Those are the things that the AIs are nowhere near ready to replace. Maybe someday, but for now, I think that's what protects at least the older lawyers who have the experience and the wisdom to peddle. we can trust them that we'll still have something to do for the near future. Um,
well, nothing is going to replace 10, 20, 30, 40, 50, 60 years of,
right.
legal practice and
Yeah.
experience.
And the younger lawyers that are coming into the space who are getting the training, they're going to be AI savvy and they'll be able to, again, be more efficient with their use of technology. And
Yeah.
as long as the
I I
schools
I
don't
talked to about
dumb it
30,
down.
50 law students last week, and I said, "You've got to learn it.
Hmm.
If while you've got free access to
Yeah,
this."
absolutely. Absolutely.
So,
All right. Well, let's move on. This is a big story. I'll let you sort of take the lead with this, but the band members from Supertramp have been in court. Supertramp's that's a long time ago, but this case just came down. So you want to take this
yeah,
one?
I will, and so talk about a long time ago. One, it's an interpretation of a contract from 1977 that was then amended in 1983, 1984, and 1991. So isn't that a good time by all? The two key songwriters of the band Supertramp to keep the band happy, which is part of what was disclosed, I guess, in the discovery or depositions or wherever it might be, decided that in 1977, they would include all of the band members plus their manager in a publishing agreement that allocated specific percentages of their songwriter and publishing royalties. So they did not make them co authors or copyright claimants. owners. They just allowed
You
an
can have a share of the
allocation of
money.
royalties, a revenue share, or rev share deal, as we would call it
Mhm.
today. And again, over time, that was amended to add another person into the rev share, reallocate the percentages, and so on and so forth. And this was all rocking and rolling. Uh, Pun intended, until 2018 when Hodgson and Davies, who are the two lead songwriters, actually stopped paying the plaintiffs their historical publishing shares. These plaintiffs sued for breach of contract, seeking a continuation of what was been happening for decades. And really, this dispute centers around this 1977 agreement and whether, because it wasn't, when did it terminate? It was silent. It didn't say it lasted in perpetuity, nor did it say it terminated after a certain number of years or a certain triggering event. It was silent. So I guess under California law, if it's silent, and this is similar in Texas, it can be terminated after a reasonable amount of time. But California looks at it in two factors, and we'll talk about those in just a second. Um, Case was filed in the U.S. District Court for the Central District of California, actually removed to there. And it was bifurcated on certain contract issues, some pretrial motions and others. But then what we really are talking about now is the single question of whether defendants' royalty sharing obligation was terminable at will, meaning terminable after a reasonable time, or instead persisted in perpetuity, which was based on at least until the song stopped generating royalties. The trial court determined as a matter of law, without a jury, that the 1977 agreement contained no express duration and no implied duration had been shown. And so the court framed the remaining question for the jury as whether the defendants terminated the contract after a quote reasonable time. After a 6-day jury trial, the jury found for the defendants, concluding the contract had been terminated after a reasonable time. This appeal follows. The plaintiffs continue to argue the agreement created an ongoing covenant to share publishing royalties for as long as these Supertramp compositions continue to generate publishing income. Uh, Again, defendants maintained the 77 agreement contained no express duration and that no implied duration can be inferred from the agreement's text or circumstances. So, on appeal, we're looking at two principal issues that went to the Ninth Circuit. Under California contract law, did the district court err in concluding that no implied term of duration existed in the 77 agreement? And therefore, in sending the next question, was it a reasonable time, to the jury? Or if we said this another way, could a contract's duration be implied from its nature and surrounding circumstances, such as the contract could remain in force until an ascertainable event? If an applied duration existed, which is this factor one, is it the proper next question to ask the jury to measure a reasonable time under which it could be terminated? And here's what the Ninth Circuit had to say in their analysis: that the 1977 agreement contained no express contract duration, but the duration could be implied from the contract's nature. So there was this continuing obligation. And basically, the court boiled it down to, really, the contract was tied to the life of copyrights.
Mhm.
And that's how long this revenue share should continue. It triggered in me thinking about the share versus the Bono Trust estate. So
Mhm.
it was her marital distribution agreement. She, again,
Yeah.
didn't matter if they terminated the original grant, which is what happened in the Bono
Yeah.
issue. She still got her revenue share. Those actions did not defeat the share. Anyway, the Ninth Circuit reversed the district court's judgment for defendants and remanded with instruction to enter judgment for the plaintiffs on liability. The court instructed that where a contract's obligation is tied to an ascertainable event connected to the subject matter, i.e., cessation of publishing revenue when the works enter the public
Yeah.
domain, a duration may be implied. So, if it's not gonna last forever, you need to put a term into it, and maybe they wouldn't have agreed to it, the non-writing parties, if there had been a
Maybe.
foreseeable term.
Yeah.
Um,
It's interesting. I mean, this feels like one of those case law decisions that could be reinterpreted with the same outcome by saying, rather than saying there was an implied duration, just saying that the implication is that the expiration of the copyright is the reasonable time. And it doesn't sound like they actually tried that question to the jury of what was the reasonable
no.
time.
I don't know how they phrased or
Yeah.
what evidence was presented to determine what was the reasonable time.
Yeah.
So, but the jury could have come to the same conclusion.
Yeah. Yeah. They could have just said, well, keep as long as the copyright exists or is in
That
force.
is
Yeah.
the measure,
Yeah.
and so they could have reached the same outcome, but maybe it would have still been challenged, and the s
Okay. So now we
appeals
have a
court
Ninth
would have.
Circuit precedent on this particular kind of a question.
Yeah,
And I don't know what other circuits have said or done about this, and we may find out at some point, but it seems like a pretty logical approach to the case.
I think so. I mean, I know I've looked at this in Texas related
Yeah.
to trademarks and other matters as to,
Hmm.
if there is no term,
Well, and
is
that's the
it
other thing.
different when you're not getting a revenue share, but you're
Yeah.
getting access? So let's say it wasn't, well, if it was a license to
Yeah.
use one of the Supertramp sound recordings or musical compositions and it didn't say in perpetuity and it was literally silent.
Then what is a reasonable time in that license
That's
question?
right.
That's
And
yeah.
then, can you really cut off a derivative? Right. I don't know. I'm kind of
Well, I mean,
changing the
yeah. I
fact
mean,
pattern
and if
too
it had
much
been a
there.
grant of rights rather than a grant of a revenue
Revenue
share, it
stream.
would have said something like all right, title, and interest in, or an undivided X interest in, and that would not have an implied end. It's a
Yeah.
transfer of property.
That's
So,
right.
it's I
Well, I
guess
think it's there. We need to keep it in mind.
caveat for
I think
drafting.
I think it's analogous or supportive of the decision related to the
Yeah,
Bono matter that even a copyright grant termination is not gonna cut off the rights of somebody that's under a contractual obligation to receive
yeah,
those. So,
yeah. Well, I guess this means there won't be a happy reunion concert tour of Supertramp anytime soon.
I know, I'm not going to sing. I've got songs going in my head.
Well, as we contemplate our breakfast in America, as we walk on the long way home,
Yeah. Yeah, they're
um,
all in there.
they are. Yeah. Anyway, well, interestingly, in Canada, we had an interesting decision relating to privacy and information uh, carried, hosted, indexed by Google. So we're going to shift into this privacy law here. The Office of the Canadian Privacy Commissioner, the OPC, Office of the Privacy Commissioner, has issued a report of findings in a case called number 2025-002, where they were investigating Google's compliance with the law called PIPEDA, the Personal Information Protection and Electronic Documents Act. There's a mouthful for you. Over undelisted news articles. So the concern was an individual who had been charged with some kind of crimes, but the charges were later dropped. And the fact of those criminal charges remained in search results many, many years later and caused him some harm to reputation, embarrassment, job loss, and even led him to be physically assaulted. The complainant claimed that by continuing to index and display these articles, Google was collecting, using, and disclosing his personal information in a way that was no longer reasonable. Google, of course, resisted having to take this kind of stuff down. They said freedom of expression. The public has a right to access lawful news reports. It's factual information, those kinds of things. Well, the OPC assessed whether showing these articles in name-based searches met the law's test of purposes a reasonable person would consider appropriate. So search for John Smith. You're going to get results about John Smith. And is there at some point, does it come to some point where it was no longer appropriate to present old information about a person. The OPC found that Google met the accuracy requirements because they weren't responsible for the article content, but they failed in their duty to avoid using or disclosing personal information in ways that cause undue harm. Boy, there's a general amorphous, undefinable phrase, right? So the OPC concluded that harms to safety and dignity outweighed public interest in keeping the articles searchable by name. They said this is one of those rare situations where the harm to the individual outweighed the public interest in keeping the search results linked to his name. And the OPC emphasized that the underlying news stories could remain published and accessible online, that the decision did not call to delete them, but it recommended that Google delist them when the search results were for the particular person's name.
Okay.
Factors favoring the delisting was that he was not a public figure. The original case had been stayed with no ongoing risk that he was going to be charged. Articles were incomplete, outdated, and potentially misleading. And the passage of time had reduced the public interest in this kind of stuff. Maybe if he was running for office or something, it would make sense to,
pull that back out.
Back, right. Balancing privacy rights with the freedom of expression, they cited the Supreme Court of Canada saying charter rights don't permit damaging another's reputation merely to express oneself. So fundamentally, the argument we would make in a defamation case is you're allowed to say anything you want right up to the point that it causes somebody's reputation harm if it's false, although here this is true information. So anyway, so this ruling seems to establish a limited right of delisting under this PIPEDA law for non-public individuals facing undue harm from misleading or outdated search results. That aligns with GDPR and Quebec law, etc. So Google has refused so far, arguing that these decisions should be court-defined and balanced with media freedom and those kinds of things. And the OPC is now considering what enforcement options are. And there we are. So Google's not.
Yeah. So how are they going to enforce that? Are they going to just say,
great question,
Google, we're turning you off in Canada? I mean,
I guess it could geofence Google, but does that serve the Canadian public interest? I doubt it.
Yeah, I don't know. I think some lawmakers might be jumping up and down if they.
So Canada gets a step closer to this sort of European-style right to be forgotten kind of regime, and that's unlikely to happen in the U.S. because of the First Amendment. Although the First Amendment. Let's talk about the First Amendment.
While
for a minute. On the subject of speech and reputation and things. Late night television, right? This is the elephant in the room. We didn't have this in the rundown until last night, but it's about Jimmy Kimmel, right? He has been at the center of a real firestorm lately, suspended briefly after some of his remarks drew some public denunciation from the FCC chairman, Brendan Carr, who spoke out on a podcast basically threatening ABC affiliates with risking their broadcast licenses if the Kimmel show continues to be broadcast. I think no matter what you think about the words spoken about Kimmel, and this all, the jokes in question sort of centered around Charlie Kirk and his funeral and the president's reaction to Charlie Kirk's assassination and so on. Regardless of what you think about the tone or the actual words that he spoke with or the jokes that he made, I think we all really should be concerned when a government official who's sworn to uphold the Constitution wades into a situation like this and threatens broadcasters, threatens to use their office in this way to intimidate or manipulate or strong arm twisting kind of action against speech. Here, it's not so much about muzzling Kimmel. I mean, there can be consequences for
what you say.
For what you say. But what they did was they threatened the broadcasters that then went up the chain and threatened ABC and Disney. And then ABC Disney made this choice. It was under duress. It wasn't an independent business decision. It was, if not dictated by government, it was at least prompted by government action.
Right.
Seems to me that's a real violation of the First Amendment. So, but the story,
it's
go ahead.
Go ahead.
No. finish your thought on that because we're going to move on.
Oh, well, it's interesting. I mentioned to you that I'm in Tennessee
Mm-hmm.
this week,
Yeah.
and, so the local affiliate here is
Mm-hmm.
not airing. Uh, I suspect my ABC affiliate in the Dallas area is not airing, and the reason for that is they're owned by one of the
That's another thing. So,
corporate companies
yeah,
that's trying to merge.
right. So the licensees that were threatening or that were making noise with ABC and Disney are Sinclair, which is a very conservatively owned chain of radio or network of TV and radio stations, and also Tegna and I forgot.
Tegna, and that's who is our
Yeah,
affiliate in Dallas.
and there's this merger going on between Tegna and I want to say it's like Nexstar or something like that.
I think
Two
that's right.
station groups that are looking to merge, and they're going to need FCC approval. So when Brendan Carr, the FCC chair, made these remarks, it could certainly be implied or understood that he could stand in the way of that FCC approval of that merger. So, and that's a strategy that government has used recently in the Paramount merger or acquisition by Skydance, and that led, I think, to Stephen Colbert's termination and also a large payout in a civil suit against ABC against CBS, excuse me, by the president. So, anyway, that's not the story that we were planning to cover in this episode.
But we felt like because we cover entertainment law and First Amendment,
Yeah,
we
it really
needed to
is the
talk
elephant
about
in
it.
the room we had to
Yeah,
cover.
we
We had to
needed to talk
mention
about it.
So.
But Jimmy Kimmel being Jimmy Kimmel, talk to us about our next story, Gordon.
Well, you may remember a while back. I'm trying to remember exactly when, but it's a couple of years back now. George Santos, the now discredited Republican Congress member, had sued Jimmy Kimmel after Kimmel made fun of the fact that Santos has an account with Cameo. Cameo is that web service where you can basically hire a celebrity to create a personalized message, greeting card kind of a message or whatever. And I think Kimmel just sort of made fun of the sort of, I don't know, the indignity of a now disgraced public official getting on there and having to do this to make a living or whatever. Anyway, so Santos had sued Kimmel over that on copyright infringement grounds and other things. And now the Second Circuit, so the district court had initially dismissed the case on fair use grounds. So the Second Circuit now has addressed the question, affirming that dismissal and holding that the fair use defense could in fact be used. They looked at the factors. First factor, purpose and character of the use. The Cameo clips were sold as sincere, personalized greetings. Kimmel used them to ridicule Santos's willingness to say almost anything for money. So that shift in meaning was the transformativeness that you're looking for on factor one. What else? The characterization of the court was explicit that copying the entire videos was necessary for the joke to land, and therefore didn't weigh against a finding of fair use on factor 3. And on the fourth factor, Santos's claim of market harm failed because there was no cognizable licensing market for Cameo videos to be reused in parody or satire, and Kimmel's use couldn't possibly substitute for the purchase of a Cameo. The question that wasn't addressed, apparently, that I'm wondering is, how did George Santos have standing under copyright law to sue when this was I don't know, who knows what the contract says with Cameo, but it strikes to me that it's sort of work made for hire, at least arguably, that he wasn't the copyright owner of.
I haven't read the Cameo terms of use.
Yeah, neither have I.
To see, I'm not a user of Cameo. I've been out there because I've had clients who are in the entertainment space who have Cameo accounts and do provide those. So, but I don't know. You're recording them on maybe you're just giving Cameo
just some kind of a license.
A license to use
So maybe
those videos.
Okay.
But I also just want to point out, about parody. I just
Yeah.
think it's a good reminder for all of us that what many people think fits in the definition of parody just isn't parody.
Right.
Jimmy Kimmel, the show, whatever how you wanna say, whether obviously
Hmm.
it's gonna be somebody behind Kimmel who's backing this up, but the bit was written that it was commenting on, making fun of, making a parody out
Yeah.
of the original work. So the new work was
Yeah.
basing this on the original versus, I've often heard people say, let's in the
Well, it's funny and it's a
music
changed
realm,
lyric or something,
it's
right?
a funny and it's changed lyric.
Hmm.
Weird Al Yankovic,
Yeah.
he gets a license,
Hmm.
people. So, anyway, I just
He has a
always
pretty
like
easy
to
time of it these days,
well, he
but
does now, but,
right.
who knows in the beginning. So, just always a reminder, just because it's funny or you think it's
Right.
funny, it may not be a parody
Yeah.
and qualify for fair
I often
use.
have to talk about the difference between parody and satire and just raw comedy. And really, it's parody is the shortcut to a fair use finding. The others, it's not a shortcut. You still have to go through the sort of full analysis. And to their credit, the court in this case did do the full analysis and didn't
Yeah,
just conclusorily say, "Oh, it's parody, it's fair use." So
right.
that's great. That's great. Well,
Maybe the TTAB did not do a full analysis. We'll get to that at the end of this one.
this is another case involving a variant. Well, not the variant. This one is actually the F word. So this case is In re Brunetti from the Federal Circuit this year, an attempted registration of the F word as a trademark. I'm going to say the F word rather than the whole word because we have a clean rating and I don't want to change that. So,
That's right.
um,
It has 4 letters, in
yes,
case anybody's
yes,
confused.
yes, yes. So
That's what
Eric
word is.
Brunetti is the same designer who had previously litigated the case of Iancu versus Brunetti in 2019 over the mark FUCT. You may remember that was there. In that case, there had been a finding that the Trademark Office acted out of order because it was this whole question of whether scandalous mark was a
Right.
legitimate reason to deny registration. So he had sought to register the F word, across multiple classes of goods and services, clothing, jewelry, bags, beverages, and so on. And it was refused registration under Section 2A, immoral and scandalous marks.
No, not
I'm
under.
sorry,
It was
not
actually
under that.
not
Sorry.
under
Right,
there.
right,
Yeah.
right. But on the ground of failure to function as a trademark. And the examiner concluded that because the word is a commonplace term used in lots of different contexts, consumers would perceive it as expression, not a source identifier.
So I'm just gonna
Yeah.
interject here. The trademark applications were filed under 1B,
Hmm.
which means they were filed with an intent to
Right.
use. So there were no specimens submitted
Hmm.
to see exactly how the mark was going to be used. Okay. So I just think that's part of the
Yeah.
conversation.
And maybe if the word was on the tag of the garment, that might still be a trademark use.
That might
Um,
be.
but
Okay.
we didn't have that to go
Instead of
on.
just being expressive
Right. Right.
type
So
type deal.
So Brunetti takes the case to the Trademark Trial and Appeal Board, which affirmed and held that the mark failed to function as a trademark. And the board emphasized the widespread use of the word on merchandise, media, and expressive contexts, and concluded that the public wouldn't see it as a brand. Okay, maybe that's a valid interpretation. But Brunetti didn't like that. He took it to the Federal Circuit and argued that it was an arbitrary ruling inconsistent with other registrations, including others that use that word as part of the mark, and including the one that uses the word love as a standalone registration. And basically, there was no principled standard behind this ruling. He also raised some constitutionality and retaliation arguments. The court ultimately didn't resolve because it vacated on narrower grounds. So, in a majority opinion, the Federal Circuit vacated and remanded the refusal, finding that they had failed to articulate a clear and rational standard excuse me, for when a ubiquitous all-purpose word can or cannot function as a mark. They criticized the TTAB reasoning as opaque and ad hoc, resembling the "I know it when I see it" approach, which I get a kick out of. And they stressed that under the Administrative Procedures Act, agencies have to provide reasoned decision-making that connects evidence to their conclusions. So basically, follow the law and explain yourself. And directed the TTAB to on remand to adopt a more coherent methodology for evaluating failure to function refusals involving commonplace words. So,
Okay, I have to thoroughly support that
yeah,
as a
totally.
trademark practitioner
Yeah.
because what's happening in my brain is
Mhm.
Apple. Is that not a common everyday word? But
There you
yet
go.
we know there are many strong trademarks
Yes.
related to the common everyday term
Mhm. Mhm.
Apple.
Yeah. I think it was just an antipathy to that kind of language that motivated it at some point. Um, so there was a dissent in the case. The Judge Lurie would have affirmed the dismissal. He said yes, the word is too ubiquitous and multipurpose to serve as a trademark. Consumers see it as vulgar, not as a source identification, which I think is true. And he distinguished it from those other marks like love or F cancer, which are more context specific and thus capable of being perceived as brand identifiers. But anyway, he warned that ignoring real world perception, that no reasonable consumer would view this word as a trademark, it was a slippery slope, dangerous thing. And
Yeah.
I think there's truth in that too.
Right.
I think it was a rightly decided case, but that dissent is useful in.
I think so too. And so what's interesting is that Brunetti filed 5 applications just for the F word.
Mhm,
He filed 1 application for F it Friday and
mhm,
another application for just F it. So 7
yeah,
applications in total. He made the choice to file this because
controversy.
he wanted controversy and to get a ruling.
Yeah,
Why in the world did he spend all those filing fees? I mean, 1 application could have probably got you where you wanted to go, Eric.
yeah, yeah. Well, crusaders do what they do for reasons other
There
than
you go.
economics, I guess.
Yeah, yeah. So, anyway, that was my real world
Yeah,
reaction. It's like, did this really require 7 applications to trigger a refusal and a TTAP decision and an appeal?
right.
I don't know. But, cover all your bases.
Yeah. You take the next one.
Yeah, so the DC Circuit reinstates the Register of Copyright. That's kind of,
Mhm,
I think that's beautiful news.
yeah,
They've weighed in on a consequential copyright administration fight involving Sharia Perlmutter, what
mhm,
was the existing current Register of Copyrights, who was abruptly fired by the president of the Trump administration in May of this year. Uh, Timing wise
mm,
seems interesting. It was only a day after the Copyright Office released a report warning that the use of copyrighted works to train generative AI raised serious legal concerns. The report she challenged, Ms. Perlmutter, the removal her removal in a divided panel, not the full,
right.
panel, but a panel of the DC Circuit has reinstated her, at least temporarily, finding that her termination was likely unlawful. It really is a separation of powers decision, and who does she report to? Who has the authority to change her employment status. The register an executive branch officer who can be removed at the pleasure and serves at the pleasure of the president, or a legislative branch officer who's insulated from direct executive control. The majority in this case leaned toward the view that it was legislative, emphasizing that the registrar advises Congress and reports to Congress and is appointed by the Librarian of Congress, not by the executive branch.
Sure sounds like
There
a
was
legislative officer to me, but
Yeah, and then the dissent took the opposite view, warning that the register exercises executive functions in administering the copyright system and therefore fall under a presidential removal authority. President Trump has asked for a full DC circuit to rehear the panel's decision of reinstatement. Uh, His lawyers argue that the panel erred by treating the registrar as a legislative officer, pointing at the role involves executive functions like issuing regulations and overseeing copyright. So, what do you opinions on if there is an en banc review? What does that trigger? What do you think that's going to signal to us?
Well, I think because it was a divided panel that made this decision, the request for en banc review just says, well, okay, maybe there is a majority of the judges on the whole panel that will disagree with his ruling. Instead of just 2 out of 3, maybe however many it is on the total panel, maybe we'll get 7 out of 13, or
Right.
whatever it is. So I think all it signals to me is that the White House and President Trump are firm in their convictions about its authority, their authority to take these kinds of actions. It sounds like sort of almost whatever action they want. You work for the government, you work for the president, he can fire you, is sort of that attitude. I found myself, just as you were talking about the facts, I found myself wondering, where does this Register of Copyright salary come on the budget? Which department is it there? Does it come out
It's
of,
for the Library of Congress.
well,
I think it has
and
to
that
be.
presumably comes out of the congressional budget overall. It's all allocated by Congress anyway, right? I guess they could shift it around to look like it's an executive branch office if they wanted to, but it'd be interesting to see. I mean, it sure strikes me that this is a legislative branch office, and
And I know we looked at this when we talked about this when it happened, when she was terminated.
yeah,
Is the Librarian of Congress an executive branch? I think
I
they
think that
may
is a
be.
presidential appointment. I think you're right.
That's right. But the Librarian of Congress appoints the Register of Copyrights,
Mm.
who reports to Congress.
Yeah, I mean, it really is an interesting separation of powers and
Yeah, yeah, yeah.
questions of independence generally, of various offices in the government. So, yeah. So look, if the register can be removed for issuing reports that displease the White House, then that makes copyright policy yet another political football, and that can be troublesome. So, is the judiciary willing to check executive interference in copyright policy making? So far, that's the signal, but we'll have to see what an en banc court has to say about it. The stakes are pretty significant here. So,
Yeah.
yeah. Well, speaking of big stakes again, and copyright law and big reversals, Walt Disney Studios, also in the news for reasons other than the Kimmel suspension from last week. So back in June of 2022, episode 146, we talked about this case, Reardon LLC versus Walt Disney Studios Motion Pictures. The case is now in the Ninth Circuit, decided September 11th. This centers on the film Beauty and the Beast and the facial motion capture system software known as MOVA that was used in the making of that live action Beauty and the Beast. Reardon is the owner of that software, and Disney's visual effects contractor, Digital Domain, used that software during production, but didn't have a license for the software. So Reardon claimed that Disney was on the hook for both contributory and vicarious copyright infringement. The jury agreed with Reardon on that vicarious infringement claim, but the district court set the verdict aside with a judgment as a matter of law for Disney, saying that Reardon hadn't shown Disney had the practical ability to control or stop the infringement. Reardon appealed. So I guess basically saying Digital Domain was an independent contractor in at least some regards. So now the Ninth Circuit has reversed that ruling. The panel said that there was indeed enough evidence for a jury to conclude that Disney had the practical ability to supervise or limit its contractors' infringing conduct. And the court pointed to its contractual rights to oversee the work, to terminate if infringement occurred, and the fact that Disney personnel actually attended the MOVA capture sessions. All of that, the court said, was more than enough to send the issue back to the jury. But the Ninth Circuit didn't give Reardon a total win. They said that they did uphold the trial court findings that there's no available remedy of disgorgement of profits
Mm.
under the Copyright Act, and certain expert testimony and indemnification evidence were properly excluded. So still, big picture, Disney is once again facing liability for this infringement, and the case goes back to district court and presumably another jury trial on some of those issues. Wow. These things do go on, don't they?
And again, this is because I guess they had knowledge, probably a level of control that they're not wanting to
Yeah,
express
mhm.
over how the production company used this MOVA technology.
Well, and how would Disney have known, even if its employees were in attendance at the capture sessions and things like that, how would they have known whether the software was licensed or not? I find that a troubling thing. If you make a contract with an independent contractor, I think it's an implied covenant in every contract that the parties are going to do their work lawfully
Well, I'm sure there's a big fat indemnification
and a
going
warranty.
back, but
Yeah, exactly.
yeah, but I suspect Disney is the one with the deep
Well, the
pockets,
deep
as we
pocket, of
like to
course.
say.
Yeah.
Yeah.
But I don't know, for a jury to conclude, well, you knew or should have known that that was
Mhm.
unlicensed software, unless there's a big red flag that pops up on the screen saying this is unlicensed software, and somebody would have seen that. I don't know how they. I don't know how they could be charged with having the ability to supervise or limit something they couldn't
Mm.
tell about.
Yeah, and that's where we don't know what the testimony
That's the jury
reveals.
case. Yeah, exactly.
It could have been, "Oh, hey, by the way, we don't have a current license for this," or, "We
Right.
were beta testers, but we never paid for a license." Maybe they just
Yeah.
told them,
Yeah.
and that came out in discovery.
Could be. Could be. Or maybe it was in the negotiations in the beginning. We don't use that software. We don't have that software. And Disney said, well, we want you to use MOVA. you know. Um, so maybe there's testimony of that. Who knows? Well, speaking of cases going on, I think this may be one of the longest ones, single cases we've ever had. We first talked about this case, episode 28. This is episode
Oh my gosh.
184. So that was
In
2012.
2012.
Yeah. So the case is the saga of Kim.com and his site Mega Upload out of New Zealand. So when the Mega Upload takedown and extradition fight first began in the 2012, 13 years later now, New Zealand High Court has now rejected Kim.com's latest attempt to block being extradited to the United States. So he's been hanging out in New Zealand in jail, presumably, for 13 years, waiting for his chance to defend himself in court. Avoiding his chance to defend himself. So the background is this. The U.S. indicted .com and some colleagues, claiming that the Mega Upload operated as a global piracy hub. Prosecutors charged him, all of them, with criminal copyright infringement, racketeering, money laundering, and wire fraud, alleging that Mega Upload facilitated billions of illegal downloads and cost rights holders over $500 million in losses and generated hundreds of millions in advertising and subscription revenue for the operators. Shades of AI in here, I think, but anyway.
Yeah, and I just, because we haven't talked about this since
Yeah.
2012, the person legally changed their name to
Kim.com.
last name .com,
Yeah.
DOTCOM, just in case anybody's wondering what we're saying
Right.
and why we're saying it that way. Okay.
Good point. So, years of appeals, have gone around in New Zealand, and the Supreme Court in New Zealand finally in 2020 cleared the way for extradition. Then in 2024, the Justice Minister formally signed off on surrender, and then .com files for judicial review, arguing that was an unlawful decision, political bias, bad faith, disproportionate punishments, discriminatory treatment compared to his co-defendants who were able to cut deals in New Zealand. And the High Court didn't buy it. No evidence of political motivation or bad faith, and the minister had properly considered .com's health, the long delays, other discretionary factors. And on the punishment argument, the judges acknowledged that he might face a stiffer sentence in the U.S. than at home, but that disparity didn't rise to the level of shocking the conscience. So now the extradition order is intact. .com is one step closer to facing U.S. justice under copyright and racketeering charges. So we'll see. We'll see.
Do you think they regret that name change?
I don't know. I would, but who knows?
Yeah, it just really didn't hold up as
Right.
good
Right.
as you might have thought. Anyway, so let's talk about another blast from the past,
Yeah.
Napster. Napster, you
Wait,
say?
Napster?
A Napster? Yes, we're going there.
Okay.
So the Mechanical Licensing Collective, which we're just going to call the MLC
Mhm.
because that's what they go by, formally terminated Napster's blanket license, which was under the Music Modernization Act of 2018. The MLC administers these nationwide blanket licenses for mechanical rights and musical compositions used by digital music providers. Um,
We
well, I
we should
guess
be
they
really
say that
clear
instead
that
of
Napster is not the Napster of the early '90s where the file sharing software.
that's right.
The
They have
brand was acquired by the service known as Rhapsody and then adopted as the replacement for, so it's a streaming service
it's a
nowadays.
streaming service that up until their license
Well,
just
yes.
got pulled, was not the file share Napster, like you said, of the 90s, late 90s and 2000s. Anyway, they license platforms such as Spotify, Apple
Mhm.
Music, Amazon, Napster's in that
Yeah.
type of platform. The digital mechanical royalties are set by the
Mhm.
statutory and by the Copyright Office, and so or actually the Copyright Royalty Board sets those. And, it's a matter of remitting those pennies and fractions of pennies from those service providers over to the MLC, who then
Mhm.
processes those and allocates them to the publishing companies. But Napster decided to stop paying. So the MLC sent Napster a notice of default earlier in 2025, alleging they had failed to make required royalty payments and reporting obligations. There's a statutory cure period. Napster did not remedy that default. So, effective August 24, 2025, the MLC issued a notice of termination of their license. So, what's the significance of this? Without a blanket license, Napster no longer has statutory authorization to reproduce and distribute musical compositions in the US. I'm going to clarify that to say
Mhm.
it's related to the digital
Right.
distribution. That means it could face copyright infringement
Mhm.
liability if it continues to do this. I'm not a subscriber or user of Napster, but I suspect they're still doing it.
Mhm.
It would need to negotiate direct licenses, which we know how that is such a
Oh, such a,
delightful
yeah.
and successful process. Um, and it the termination underscores the MLC's willingness to enforce compliance, and I think they have to enforce
Oh, yeah.
compliance. I mean, they were formed by statute. They've gotta enforce
Part of the role,
compliance.
absolutely.
That's right. Obviously, one of their roles is administering these royalty
Mhm.
payments, but I think they also have to take care of the protection of the rights that have been granted. Um, Industry observers are noting this could be a warning shot to other platforms. I think it means that we need to know MLC is doing their job.
Yeah. Yeah, I
So,
think so.
anyway,
I mean, you have to wonder, are other platforms going to be as vulnerable to? I mean, look, if you miss your payments, you're going to have consequences. I guess that's what it comes down to. But I wonder if Napster didn't get singled out just because of the negative perception in the industries of that brand. Rhapsody obviously thought it was worth adopting the name for its service, but those of us that were around in the early '90s, we thought of Napster as kind of, I don't want to say evil, but a lot of us were
right.
perceived it as this sort of scofflaw operation, I guess you
Yeah,
could say. So,
it was free for all.
yeah,
If you could get to the technology, you could do what you wanted
but
to, and
but I don't think that's a reason that other folks should neglect their obligation to pay their
yeah, I don't
licenses.
either, and I mean, the MLC is also, they've done a really great job for music
Mhm.
copyright owners as far as
Yeah.
getting distributions out and releasing money that was held for a long time by the various platforms and finally got it collected and paid.
Mhm.
So I think this to me signals one more step of they take their job seriously.
Yeah. Yeah. Well, In another matter involving Napster, this one is Lowry versus Rhapsody International. We had a case involving a group of songwriters who brought a class action against the service, then operating under the name Rhapsody, over unpaid royalties for uses of their works. Well, years of litigation went on, and finally a settlement was reached. It was actually a class action. Benefit to the class turned out to be about $52,800 distributed to class members.
That's tough.
Yeah. And then, talk about chutzpah. The class counsel requested attorney's fees in the neighborhood of $1.7 million, arguing that their time, effort, and the Lodestar ruling justified the award even if the class recovery was small. So the district court initially had granted those fees, but then I think they rightly took it up to the Ninth Circuit, and the Ninth Circuit reversed, saying fee awards have to be tied to the actual results the class members receive, not just hypothetical maximum recoveries. So on remand, Judge Jeffrey White in the Northern District of California reassessed and awarded the class counsel $86,000 in fees. So still
95% reduction.
Yes. And still more than the total payment out to the actual parties in interest, the class
Is
members.
That probably kind of normal? I hate to say.
I imagine the
I mean,
I
I realize that many of those fees are very much earned based on the work that is done in a class action. I don't want to say that's not the case, but it's kind of like taking something on a contingency. You just can't get 1.7 million when the total class got 53,000.
Well, right. And so we have this ruling as sort of a rebuke to the council who go after these large fees when the class is getting a small settlement. I think that it basically says, hey, lawyers, if you're doing this, keep in mind the amount of the actual award when you start asking for attorney's fees, because we're not going to be rubber stamping your attorney's fees. And the judge said, yes, the lawyers spent their time on this, but a lot of the work wasn't that complex. And with the class members seeing very little direct benefit, it would be sort of unequitable to award such big attorney's fees. It's a trend towards stricter scrutiny of these class action settlements and fee requests, especially in this copyright and royalty space where damages can be spread out over an awful lot of people and amount to a very small amount per.
But I've always kind of felt like part of the motivation to get a class settled was because of the hit of attorney's fees.
Sure.
And now
I think this really will make it harder for plaintiffs with small individual cases to get justice.
Yeah, I am a little concerned. I mean, I'm not saying I disagree with the judge's decision, but I think it's just going to make it hard. And it may make it hard for people to get the type of representation they need.
That's what I mean. Yeah. I think, the good news is it seems like this is an ad hoc, fact-specific ruling on this case. But it should also be, it should inform the thinking of potential class counsel about whether I'm going to take on this case. If it really means, well, your claim, Mr. Lead Plaintiff, is really only going to amount to 52 cents for you. I shouldn't expect to get thousands of dollars in legal fees for each version of you that I'm representing in this case. So, I guess it's a matter of, I guess that streamlines dockets a bit too. So maybe there's an upside there.
It could.
It's all in the name of administration of justice, I guess. So anyway. Well, that brings us to the end of our episode. And I want to say a big thank you to our loyal listeners for being with us and for spending your time with us. And again, if you have feedback for us, we do hope that you will leave it for us using that voice widget, the website at entertainmentlawupdate.com, or an email to entertainmentlawupdate@gmail.com, or reach out to either of us on social media. We'll tell you how to find us in just a moment. Actually, why don't you tell us that now, Tamara?
I will, Gordon. So you can find me on social media at Tamara Bennett, TAMERA BENNETT in most places. Website, harperbates.com and createprotect.com.
And I'm Gordon Firemark. I'm based in Los Angeles. My website, firemark.com. My email is gfiremark@firemark.com. Most social media sites, I am gfiremark. On Instagram, it's my full name, Gordon Firemark. And yeah, I'd love to hear from you. I want to also say thank you to our team of volunteer contributors. We have John Janicek, our managing editor, Charles Thorne, Alexis Allen, Violet Zhang, and Dawson Holder all contributed to this episode. And listen, if you are interested in joining our little family of contributors and helping out with this, and it's fun, reach out to us. entertainmentlawupdate@gmail.com is the place. Send a resume and a cover letter, and we'll take a look and be in touch. And that just about wraps it up for this episode of Entertainment Law Update.